You may be seated. We are back with the same appearances as before. Attorney Labrie, have you had an opportunity to confer with the victim?
Yes, Judge. We did have an opportunity to confer with the victim. We did answer questions and gave her an opportunity to have some time. Based on our conversation with her, we are not opposed to staying the proceedings and adjourning the trial.
And is that on the basis that the state also wants to appeal my ruling rejecting the plea agreement, or is it on the other basis cited by the defense that they think my ruling in April 2023 and Judge Rohr's ruling in September 2022 are too late notice for them to prepare regarding the social workers?
Our reason for not objecting is that we're trying to minimize appellate issues after trial. So to have these dealt with ahead of time prior to having to put on testimony, we would rather whatever appellate issues are occurring, have them dealt with so that when we go to trial, there's finality.
Which I do understand. Is there anything else that the defense would like to add on that issue?
I don't believe so, Your Honor.
The motion to stay the proceedings and adjourn the trial, as I alluded to, cites two grounds. One is the court's ruling denying rejecting the plea agreement and then denying the motions to reconsider. And second, quote, and given the late decision by the trial court on the issue of the admissibility of the social worker's testimony, despite the defense filing its offer of proof in April 2022, adequate preparation for trial is difficult within the established time periods, which consists of 3 days, end quote. I've already commented on that last one briefly, that my order entered on Friday stated that what I said earlier still stands. The protected records remain protected. The social workers are competent and able to testify in any other regard, but that was a correct ruling in the first place. And I entered my ruling, again, April 20th, 2023. Judge Rohr issued his ruling on September 8th, 2022. So far more than 3 days. None of this was a surprise. And the ruling I entered on Friday was a surprise to anyone. As to the request to adjourn to appeal the denial of the plea agreement, I think it's clear from what has been filed here and from case law that I've acted well within my discretion. I think the issue that the defense takes is with out-of-context comments, which you put into a motion you wrote before you had access to the transcript, which I think was just granted in the last hour or so. Right, the defense has determined that I have prejudged this case. And again, that ignores half of what I said and half of the reasoning. It ignores the other factors that I talked about at great length. It ignores the discretion that I have, as was confirmed by the Wisconsin Supreme Court in Conger and in Kenyon. And it ignores my obligation to independently review any plea agreement. That you don't like the ruling does not make it an improper ruling. The defendant's rights are preserved without staying this proceeding. If you get a new judge, there's no guarantee that that judge will accept the plea agreement either. There's no guarantee that any judge will do anything. That's part of the process. And if Mr. Hauschultz were to be convicted at trial, he's free to appeal all of these rulings. If he's not convicted of anything, then there's no issue. So I'm not satisfied that staying the proceedings for purposes of an interlocutory appeal would materially advance the proceedings. I don't enter a ruling thinking it's going to be overturned. And in terms of the issue of bias, again, that's half of the argument I made. It's one of the factors I cited among many. And as the Wisconsin Supreme Court reiterated, for example, in 2015 in State versus Herman, Herrmann, 2015 Wisconsin 84, there is a presumption that a judge acted fairly, impartially, and without prejudice. I am not satisfied that we in any way materially advance these proceedings that have been pending for an extraordinarily long period of time by further staying them. So I'm going to pause here and allow the parties to respond because, quite frankly, springing these on me at the last minute is also unfair, and I want to make sure that we are proceeding cautiously. So I'll turn to the state first. Can you tell me how this would materially advance the proceedings?
Judge, the state's perspective is coming from putting citizen witnesses on, and the nature of their testimony is extremely traumatic. And we only want to do it one time. Not saying that defense will win on appeal. We don't know. That's for the Court of Appeals to decide. Our concern is making sure that this is a one-time thing where they would have to testify and go through that trauma and significant issues that come around with that. So that is why we do not have an objection to staying it and allowing these issues to be resolved so that they are resolved. And we only have to do that one time of testimony.
I should ask more directly. I know you conferred with the victim.
Yes.
Is the victim in favor of the stay for purposes of appeal?
That's my understanding.
And from the defense?
A couple things, Your Honor. First, no judge who is recused after an appeal believes that they were biased, because otherwise they would have recused themselves, a decision that's not subject to review. So respectfully, I'm more concerned with the Court of Appeals' independent de novo analysis of the comments and statements that were made by the court at the hearing rejecting the plea agreement than the court's own interpretation of those comments. We all have the transcript. We were there. It was video recorded. I think the court's comments speak for themselves. Second, we will be asking the Court of Appeals for a stay when we file the interlocutory appeal. Procedurally, we were required to ask this court first. Third, on the issue of the social workers, I think it's hardly the case that these were issues decided years ago. The preliminary ruling Friday took into account additional briefing and litigation on the issue, and also missed the fact that the state's expert Pesca has had all of the copies of the CPS files provided to her. They form the basis of part of her opinion. She references them throughout. So if that ruling of the court is to stand, we would ask for the exclusion of Pesca, because obviously we cannot challenge the basis of her expert opinion if we are not able to have access to the documents she relied on. So the state can't have it both ways. The state can't claim that they do not have those records, therefore have no ability to prepare or respond to the ones we were asking for, but also have provided them to an expert witness hired by the state who rendered an expert opinion, including statements that were in those confidential records.
Well, I think you're jumping ahead. We have a motion on file to exclude the state's experts, so.
For a completely different reason.
Right, but we can take that up then. Or is this something else that you intend
The
to
court
appeal?
implied that we are saying that we don't have time to prepare for 3 days based on 2-year-old rulings. Obviously, that is not what we are saying. We are saying there are unresolved questions as to the scope of the testimony. It is one thing for Bellows records to be inadmissible. It is entirely another for the court to say the subject matter and independent personal knowledge of the social workers that work on CHIPS or JIPS cases is beyond the reach of defense. Bellows does not stand for that proposition. There is nothing in Bellows or Hebert, which Bellows is based on, that speaks to the testimony of social workers. Based on that, that is the question that is unresolved. That is the question we asked the court to rule on, that the court ruled on Friday. That is still unresolved because, as far as we are aware, corporate counsel wanted to be heard today on that issue. So it's hardly accurate for the court to act as if we're objecting to rulings 2 years old when the court has not even given a final ruling or heard from corporate counsel on that issue and said that the court would do so today. So I think that there is ample basis for each of the motions that were provided to the court. They were well laid out. They are factually detailed. They quote from the record. If the court wants to check the quotes from the motion that was created prior to the transcript being created, I think you'll see that they are accurate. And other than that, we have laid out in our motions everything that we need to say on the matter.
I never said you were inaccurate, Nikki. I said you were quoting me out of context. There was a whole lot more I said than those 2 lines you cited. But
After the decision had already been announced.
All right. I, again, had this sprung on me with no notice. These were not properly noticed. I've had no time to review the record, the case law, anything else. I'm going to have to take a moment to review it. The motion to stay the proceedings and adjourn the jury trial pending interlocutory appeal. I'm going to have us come back at 1 o'clock so that I can have some time to review additional case law and consider the arguments. Attorney Conrad is here from Corporation Counsel's office. I don't know if you want to be heard at this point. It is very kind of out of order, but since you're here, we could at least get that part taken care of.
I would appreciate that, Your Honor.
All right. We need to get you to a microphone, please.
Thank you, Your Honor. And perhaps this is more of a need for clarification, after reading the preliminary order. I wanted to be clear that this court was not permitting testimony pertaining to any youth or juvenile or their records or any of their records in the in this matter that's currently before the court in 19 CF 75. And I simply say that based on prior rulings from different branches, as well as the fact that there has been no order from a children's court to authorize a release of any confidential information, which would include up to and including the fact that the department even had, I would say, contact with an individual.
I appreciate that the facts in this case hinge on information that was otherwise protected. That's where the case starts. I think that there is a way, though, to craft testimony. There is a way to craft an agreement as to how that will be handled that does not breach the protections in statute of these confidential records. And the fact that children are the named victims in a criminal complaint does not change the analysis for a Bellows motion. And I'm not interested in relitigating those motions which were heard by another court and by this court. And that ruling was upheld by the Court of Appeals in the Branch 1 case and was not appealed in this case. So the records are protected. The information in those records is protected, whether it's a piece of paper or testimony about it. And I don't know how I could be more clear that that protection needs to be upheld. That a prior order, a prior ruling of the court doesn't get overturned now because it's inconvenient. We can find a way to work out the best way to get us to the point so the facts make sense.
And I would point out that part of the state's position in one of the two bellows that was appealed was just simply untrue. And so the investigation of Ethan's death had no CPS involvement, was a position the state took on the appeal that the court based part of its ruling on. Obviously, we know that's not true. Laura Zindler was the one that did the interviews with the detective.
And you're referring to the branch 1 ruling, just so
Yes.
I'm clear which one we're talking
Yes,
about?
the branch 1 ruling that was appealed, part of the...
And upheld.
And upheld. Part of the denial was based on facts that just simply are false. The state claiming they did not have the CPS records in their possession or knowledge of them. That was the heart of the Brady challenge that was raised. The state claimed they did not have them, did not have access to them. Obviously, we know that's not true, given they provided them to their expert. Second, nor has TH offered anything to suggest that CPS had any involvement with the investigation of Ethan's death or criminal charges. We obviously know that's not true. Laura Zindler did the interviews with the detective after the children all invoked during police interviews. They were brought back on the guise of, should we do a temporary physical placement?
So are you asking that I overrule Judge Rohr's ruling and the Court of Appeals ruling, or what are you asking for?
No, I'm pointing out that the issue in the Branch 1 case was not the admissibility of the facts known personally to the social workers. Bellows covers records. Information known to the social workers is not records. So while the records were denied, nothing about the Branch 1 ruling or the appellate decision upholding that would go to the knowledge of the social workers themselves unless otherwise protected by a statute unrelated, which we have not discussed or ruled on.
Give me a citation for the proposition that protected records are confidential, but testimony about those protected records is not.
The statute itself. Let me find that. The records of an agency regarding an individual who is or was in its care or legal custody must be kept confidential under the statutes that Bellows is based on, 48.782A for Chapter 48 cases and 938.782A for Chapter 938 cases. Confidentiality of a record. The entire Bellows framework is based on access to records. That is because in most cases, the individual seeking the record does not have them, does not know the information contained in them, would not know who to subpoena to get testimony. We're in a position where we had them, wanted to use the documents themselves for some of the contents in them, and needed permission to do that. That permission was denied. We are in the fortunate position of knowing the individuals who have firsthand knowledge and would like them to testify about their knowledge and participation in those cases, which goes to the heart of the defense raised here. We don't need the records for that. We would like to have them. The court has denied that. We are fine with that. But the social workers themselves participated in this case, participated in conversations with Mr. Hauschultz about the discipline he used. That is not a record. That is not subject to those privileges. That is not subject to the Bellows ruling. So we've been asking the court to clarify that we are not prohibited from introducing those, given no other case.
So you want the social workers to not review any of the confidential records because they can't testify to what's in those confidential records and rely on their memory of something that happened almost 7 years ago?
Absolutely. In this case, knowledge and awareness of the use of wood carrying and gravel shoveling, when they did home visits every month to this house and saw the children.
All right, I need to stop you because I think you are talking about the privileged information.
It is part of the open record already. It has been referenced in this case. It is part of the expert reports that are publicly filed in this case. So that goes back to the heart of the question of how can the state be introducing this stuff through its expert, yet we are prohibited from asking these witnesses directly, did you have these conversations? When our defense is based on a reasonable person's understanding and decisions based on their interactions with others and the circumstances, it is hardly appropriate or fair to not have the jury be aware of those circumstances. The Supreme Court has repeatedly recently held in cases involving both domestic violence, human trafficking, and other situations that go to these same statutory privileges in the same section, that the full picture must be available for the jury to understand what a reasonable person in that position with those same circumstances would do.
Then give me that citation. Give me a case citation that implicates 938.782A or 48.782A.
We're talking about two different things.
You just said it was the same provision. You said
No,
the Supreme Court in those contexts.
The statutory privilege of reasonable parental discipline is in the same
Right,
subsection.
but we're talking about confidentiality of records.
Right, and I'm saying the records are covered by Bellows, great. The knowledge of, the records are covered by Bellows because of statute. The knowledge of the social workers is not, and it is inherently unfair for the state to present aspects and information from privileged records, not even from the social workers testifying, from those literal covered records through their expert, while denying us the ability to question the social workers who have firsthand knowledge of their conversations with Mr. Hauschultz about his disciplinary regime. And that is necessary, as the state has the burden of disproving beyond a reasonable doubt that this was an exercise of reasonable parental discipline. The Supreme Court has said we need the full picture of what a reasonable person in Mr. Hauschultz's position would do, which includes the conversations he had, the context of his decision-making, the behaviors of the children. Everything that went into his decision as to, is this a reasonable thing to do in response to this particular type of child behavior, is admissible. The Supreme Court has said it needs to be, otherwise we are denied that defense. It is burden shifting because the state, once raised, has to disprove it beyond a reasonable doubt. So that is
So why does Bellows exist? What
To
what
protect the
protections does,
record.
hold on, just 938, 782A, or 48, 782A, if that is meaningless, if somebody raises the affirmative defense?
It's not. The court is... Someone in Mr. Hauschultz's position who did not know of the social workers, did not know what they had previously done or said, could not find out the confidential information through Bellows. If it was denied, they would have no way of knowing anything that's contained. That is not the case here because he was obviously involved in the underlying cases. We don't need the Bellows records to be unsealed, to be unprivileged, to be admissible in order to ask the people who were actually involved the questions related to, hey, what conversations did you have? Where were you? Were you at the house? What was the situation there?
I'm sorry, you need to slow down just a little bit.
Bellows explicitly deals with records. No reading of a records can include live testimony in a criminal case unrelated to that case about the contents of that person's participation. That is simply the distinction. It has nothing to do with our privilege argument or our parental privilege argument. It has to do with the distinction between Bellows covering records versus testimony is not a record, and no statute and no case has said we cannot ask the social workers directly what conversations did you have with this individual on this date about this topic.
Your Honor, I think a plain reading of 4878 sub 2 pretty much dispels that argument in its entirety. Statute says no agency may make available for inspection or disclose the contents of any record.
Again,
That goes straight to testimony. You
We're not
can't disclose the contents through testimony. Moreover, I would also point to 48396 sub 7(1)R, the department of a county department under 46(215), 4622, or 4623, which our department is, shall keep any information made available to the department or the county department under paragraph B1 confidential. This is about information, and this is about, quote unquote, the contents of the record, which goes, as I said, straight to testimony.
and the fact that they reference information having been made available tells you that the statute, speaking of records, is speaking only of records, not information. The legislator is presumed to know the difference between words, is presumed to intentionally select and know different meanings between words when they're contained in the same statute. And these social workers were not given information that was made available to the department. They are the department. They firsthand observed, experienced. That is not having information made available to you. So even under court counsel's argument there, this isn't covered. Records are not information. Records are not live testimony. If information was made available to them, they would have a duty not to disclose it under this statute. Sure, that is not the case here.
Where did the records come from if not from information that was made available to the department?
The records were created by the department based on
From
their
information that was provided to them?
No, based on their firsthand observation of the authors of the reports. The reports are the records. The social workers are the department. They created reports. Those reports are privileged. Their knowledge and their experiences are not. That is not a record.
Attorney Conrad?
That seems a bit circular, to say the least, and again, I would go back to 4878 sub 2, where it says you can't disclose. essentially either the records or the contents of the records. It speaks directly to that. I think that is a strained interpretation that defense counsel is putting on.
So if that's accurate, can we ask the social workers, what information are you aware of that you did not include in your report such that it wouldn't be part of the record? You can't put the chicken before the egg and then say, hey, we're not allowed to talk about anything contained in this record that we created, even though it is not a complete record of our knowledge. It's a record. It is not their knowledge or their testimony. Trying to shoehorn it in through records when it's clearly defined statutorily, when no court of appeals has ever taken that position, period, it is not how it works. That is not what the statute calls for or requires. If that were the case, we would have taken that position in our Bellows motions and sought disclosure of those things, but we couldn't do that because that's not what Bellows is.
Does the state take a position?
Judge, the Bellows motions are corporation counsel.
I'm sorry, Jen.
Oh, I'm sorry.
No, they are. I just want to know if you
Yeah.
want to be heard on it.
The records are in the purview of corporation counsel, so I have to defer to Attorney Conrad on that.
I think it is a very circular argument that the social workers become aware of information and put it in a record. But they can disclose what they put in a record if they remember it. And it's a very circular argument. The information contained in a record came from somewhere. And that is what you're seeking to disclose. There is no protection for these confidential records or the information contained therein if the ruling is that you can't get the actual piece of paper, but you can get everything that's in it as long as the social worker independently remembers it. That does not provide the confidentiality that the statute is directly designed and says explicitly it is created to afford the subject of these records. You can make faces all you want, but
Just hearing records and pointing out again, these are only privileged because the legislator defined that they were privileged and defined what was privileged, which was
Right.
records. So the court is saying it's circular. That's not my problem. It's the legislator's problem. The legislator has said, here's what is privileged, here's what is not. This court, based on no authority and contrary to any other appellate court that has looked at this issue, is saying no, Bellows records includes independent knowledge, independent testimony of social workers. That has never been the case.
if it is regarding the subject of those records, it is explicitly under the purview of Bellows and its progeny. All right, let's come back at, did I say 1 o'clock or 1:30?
You said
1
one.
o'clock. We'll come back at 1 o'clock so I can rule on the motion to stay for purposes of appeal.